So the Employment Bill of Rights Act 2025, we got there in the end. There's been quite a lot of noise about this, so I'm sure that all of you are very familiar with what was and once the Employment Bill of Rights Bill, not the Act. But for many, someone else. Paul, are you able to bring people in rather than me do it? Is that okay? Thanks. And so for many businesses, it started to feel like everything needs to change all at once. But today's session hopefully will give you some reassurance with that. So from day one rights to unfair dismissal, family friendly rights, expanding stricter rules around dismissal and re-engagement, 0 hours contracts. That's quite a lot to take in, isn't it? What we want to do today is help you translate the legislation changes into real everyday situations you deal with as employers or managers or HR. The what happens when moments and the decisions you make under pressure. One of the biggest shifts coming in is the reduction in the unfair dismissal qualifying period down to 6 months. This doesn't mean you suddenly have to make tough decisions, but it does mean the margin for error is smaller and the quality of your process really matters. Some of you, I'm sure, are very familiar with these things, but probation periods, sickness absence, disability, family leave, all of these things are now intersecting much earlier in the employer relationship. So today we'll focus on what this means in practice. I'll be asking Alexandra, our in-house ER expert, hello Alexandra, some of your submitted questions. There won't always be neat, risk-free answers though, and we'll be honest about that, but there are sensible and defensible ways to approach these changes that balance legal compliance with human, pragmatic people management, and that's what this session is all about. So welcome Alexandra, you are once again under the test with these questions. I hope you've got your big brain with you.
I want to say always, but I'm not sure.
You're brilliant at this stuff, so I'm sure you'll be absolutely amazing. And I know that you have been keeping a very close eye on all of this and breaking your brain occasionally on it all. So I'm sure you're absolutely brilliant. Will be brilliant with these questions. So I'm going to crack on. I've heard there are lots of changes coming into force, but I'm not sure what and when it will be coming in. Do you have a timeline?
So there is a timeline as such, and that is broken down. So there is a lot coming in, but it can feel overwhelming because of the amount of changes that are coming in with the Act. But I suppose on the good news is that it's being spread out so that employers have time to deal with things in chunks rather than everything happening at one time. So if we break it down timeline wise, I won't go into too much detail, as I'm sure there's probably questions that tap into each of these areas. But the first lot of things has mainly been around trade union activity and industrial action. So you'll have probably seen that there was some stuff already passed when the bill got royal assent in December. And that was around the repeal of strikes and minimum service levels. There will be further changes in Feb, which is just to do with trade unions and industrial action. So in Feb, there'll be the introduction of increased dismissal protection and amendments to trade union activity as well. So that's going to be things around any dismissal for taking part in industrial action being automatically unfair, which at the moment it removes the current 12-week limit for claiming unfair dismissal at the moment. Things like the time needed to give notice of industrial action is going to reduce down. That's currently 14 days, it will reduce to 10. Unions will need a simple majority vote for industrial action. Mandates will last for 12 months now instead of 6 months. Things like ballot notices will be simplified. That's pretty much it for Feb. So Feb isn't really a major operational change. It's more if trade union activity does affect you. The big hit for businesses operationally comes in April. So in April, this is where things like statutory sick pay is going to become payable from day one of sickness absence, which removes the current 3 waiting days. For those who do only pay SSP, that's a big one to navigate, not only in terms of, like budgets and costing, but it's how does that link up with payroll? Believe it or not, errors with SSP are actually one of the biggest complaints that can come through to tribunal. So getting all that lined up and correct along with policies and contracts is going to be key. Entitlement to paternity leave and unpaid parental leave is also going to become a day one right. So currently for paternity leave, you need to have 26 weeks length of service prior to the 15th week before the expected week of childbirth, because they like to make these things complicated. And then for unpaid parental leave, to be able to take that, you need a year's service at the moment, if you're responsible for a child under 18. So they're both going to change to day one rights now. The next part in April is around collective redundancy. Yeah. So this will obviously only impact if you do have a larger team and where there could be potential redundancy situations in the future that affect 20 or more employees within a 90-day period. So this is about the protective award. That's going to double from the current 90 days pay per employee to 180 days pay. And that obviously brings a heightened risk for failure to follow a fair process or any process at all. The last bit in April is then going to be the Fair Work Agency introduction. So that's being established at this stage to provide more enforcement for core employment rights with the ability and powers to inspect. They can issue penalties and they can even bring tribunal claims on behalf of workers. So it is one to look out for as well. So then the next thing, timeline wise, we're looking at October. So in October this year, the big hits here are going to be around the duty to inform employees of their right to join a trade union. So that's going to apply to everybody. It's going to have to be picked up process-wise. Stronger duties around preventing sexual harassment. So this further embeds the updated legislation that came in to make sure that there's further steps that are being taken by employers to take all reasonable steps now, and that includes third party too. Tribunal claim limits are going to be extended from the existing 3-month period to now 6 months, and the dismissal and rehire restrictions are going to come into effect at this point too. So if an employer dismisses a worker because they're not going to change to, they're not going to agree to a change of a key contractual term, that dismissal is now, as of October, will be treated as automatically unfair. So that's when you're looking at things like core terms and conditions, things like pay, benefits, holiday, hours, shifts, anything else that comes into core T&Cs is going to be a lot more difficult to change if an employee now resists. Everything else then falls into 2027. So that's where the big one that everyone's talking about around unfair dismissal qualifying period reduces from the current 2 years to 6 months. And that's going to be effective right from the start of 2027, so the 1st of Jan 27. Statutory bereavement leave will be enforced at this point too. There will be enhanced protections around pregnancy and maternity dismissal. Also, the 0-hour contract reforms come in, together with shift cancellation, compensation, and reporting in terms of gender pay gap and menopause mandatory action plans will also be enforced at this point. That last point there around the action plans is if you're with a larger organisation of 250 employees or more. I think that is pretty much it. There will be further, even more trade union and collective consultation stuff changing in 2027 as well. But I would say, like a lot of this stuff, there are, even though we know there's no movement on when these things are happening, the detail behind it all is still going through consultation in a lot of ways. So there's around 26 consultations that are still going on around the detail for all of this.
Yeah, and I think it's safe to say it does feel massively overwhelming, but if it, much of this at the moment hasn't, like you said, hasn't come through in the detail yet. So we're here to support you. So if you want to sign up to the newsletter, if you haven't already, that will give information, and we'll continue to do these clinics. So you can we can help you break down any concerns you've got. So do let us know if there are things that are really overwhelming to you, that you feel like you really need some support on. We can definitely sort of look at how we support you as a clinic or whatnot. I'm going to pick you up on a couple of points, not to question you, but just to highlight a couple of things. Quite often in parts of the creative sector particularly, there's this kind of, well, we don't really work with unions, we don't really have unions. Unfortunately, that doesn't matter. And also we're seeing a rise in the use of unions across the sector. Now, in parts of sector, unions are used a lot more. So if you're a performer, for example, you might be under equity or back to or something like that. But in video games, we are seeing a massive increase in the use of the unions. And then I think it would be churlish to say, this isn't our problem. It's an absolute your problem. And I think you need to understand it. So it's just to that point. And also around the sexual harassment prevention thing, there is now a change to the NDA as well. So that means that you can't use NDAs to silence people who have been victims of sexual assault or sexual abuse in any way, or harassment in that form. So that has just come through Zelda Phillips. If you don't follow her, she was the one who campaigned for it, and she was a victim of the Harvey Weinstein situation. And so she's sort of been very successful in advocating for that through government, and that is also a change. So I think those were just 2 points I wanted to highlight. But absolutely, we'll help you, support you through this as these changes come into place. So don't sort of panic and go, oh my God, I've got to change everything right now. You haven't, it's fine. So moving on to point 2, with the qualifying period for unfair dismissal being drastically reduced, is there any point in having probation periods now?
Yes.
Or will there be?
I would say arguably more than ever.
Yeah, absolutely.
Like, probations haven't lost their purpose in this change. I guess this just highlights how important the probation period is. So with that qualifying period reducing from January next year, I guess it's seeing that probations are no longer a low risk trial period, as such as people sometimes see them. It becomes something that needs to be far more structured and evidence based, to make sure that there are clear expectations set there. There's active performance management. You can demonstrate that there's fairness and support. You spot issues early on. You don't ignore them, because it's going to be very problematic if you leave anything towards the end of a probation period, with people then being able to claim unfair dismissal from having 6 months service and more. Also, I'd say, like, it's going to be more important now just to evaluate when you want to exit somebody from the business if it's not working out, and doing that sooner rather than later if you are identifying any red flags.
Okay, so, and that kind of takes us on to the next question, really, doesn't it? I've heard we'll have to be better at managing probation periods through the first 6 months of employment. Do you have any practical steps for this?
I think in addition to what I've just mentioned, probably it's reiterating that, don't wait for the end of the probation period, whether that's a 3-month one or a 6-month one. Don't wait until the end of that time to try and make a judgment call on something. You should be having, when somebody starts with you should be having weekly check-ins to start with, and then ideally every 2 to 4 weeks, and then you can gauge how somebody's getting on. But throughout the whole of that probation period, the line manager should be having regular check-in points to know exactly what's going on, how that person is, not only in terms of their settling in and progress with the company, it's their well-being side of things. So it's going to be really, really important to document and discuss all of these matters, make sure that any concerns are written down early, and provide them with time to improve, but saying that not an endless amount of time. We've seen historically where people just want to extend and extend and extend.
Yeah.
And they're going, what's the point? Like, it's not a solution at all. And it's going to be even more paramount now to not extend, because you are going to, if you've got 6-month probation in place, for example, and you then think, oh, I'm just going to give them a little bit more of a chance, you then trip into them being able to claim unfair dismissal if a month down the line you're then thinking, I've made the wrong call here, performance is still not great, I want to exit them from the business. It's going to be so much more tricky, and there's going to be so much more risk attached to that.
And I think it's important because this really is about, there's a couple of things. It's about, you've got to be quite proactive from the minute that they start, really, about their employment, is much more aware of kind of the questions that you're asking from the beginning of employment. Those are things that might include reasonable adjustments or adjustments that need to be made, but they're also things around kind of, how does a line manager have a good conversation? And by good conversation, I don't mean, oh, how was your fish and chips last night? I mean, actually being able to actively listen and understand that there might be some wellness issues, there might be some performance issues that are, either on the company's side or the individual's side, but being much more readily active to respond to those rather than sort of waiting for time to settle in. And that in itself, I mean, that's a just debate in itself, isn't it, whether 6 months is ever fair or reasonable, and even in itself. But that's not for us to, given what's gone on with this employment rights bill, I don't think that's for us to contest at this point. But it is about, how do you get people to be ready in a line manager point of view, a leadership point of view, and proactively ready, and what flags are they picking up, and what are your weaknesses? And those are things that we embed repeatedly, but it's important to pick that up. Okay, so moving on to the next sort of question then. So what happens if we've got that 6 months probation period in place and a line manager wants to extend? You've just answered this, really, but is this now risky?
Yeah, it's risky. Yeah. I would just say avoid it, avoid extending beyond 6 months unless you have a very strong documented reason and you feel like the risk is going to be low. But yeah, on most accounts, I would say don't do it.
So, for example, if somebody was off, during that 6 months period, for a particular reason, let's say it's absence related due to sick health or a family member, those might be good opportunities to extend, because you can document that you've actually, why that person's been off and what measures have been taken, for example. But we would hope that that's unusual, particularly in the first 6 months, and we would hope that you also have the guardrails in place to protect with that sort of thing anyway. So I won't go into too much detail and break these things down, because I'm firstly conscious of time, but secondly I'm going to break Alexander's brain if I throw too many curveballs. So I'm going to just keep moving the questions down the line. But if you have any questions at the end, do feel free to ask us. So is there any point hiring employees if people now have day one rights to unfair dismissal? Should we instead consider taking on more freelancers?
This is one that's actually come up quite commonly in terms of discussions in the sector, but it comes with a lot of risk if you just take it at face value of, oh, we're going to hire freelancers now, we're not going to take on any more employees. Like the act in itself doesn't remove the distinction between worker status, so you've still got the classification issue between employees and freelancers. And if you need people to work for you continuously over a period of time, they're going to be classed as an employee, whether you think they're a freelancer or not. So the misclassification risk is increasing, not decreasing. Coupled with things like the Fair Work Agency coming in as well, they're going to have stronger enforcement powers to pick up on this kind of stuff, and where companies are potentially trying to get around loopholes in a way. So I would say the smart approach here is, use freelancers where the role genuinely requires a freelancer. Consider the impacts as well of, you're going to have heightened freelancer rates, so does that align with budgets as well? But realistically, the measures that are coming in here are all around good practice and fair practice. And if you're doing things in a fair way, and you're documenting things, your risk is still low.
Yeah. Yeah.
That's how I would see it. You know, you're always going to need some amount of control for some of the work that you're doing, and you can't have that control if you have all freelancers working for you. So yeah, it's obviously very dependent on the business and the size and what's needed. So I can't really answer it specifically, but that's my general guidance.
Yeah, and I guess it's realistic to say, you know, there is always a balance between sort of contractor, freelancer, and an employee person. But you're absolutely right. If you need them continuously, they're an employee. You still need an employee. You've got to be more proactive, I think, from the beginning, and that's the sort of long and short of it.
Yeah.
Okay, so we're just going to come on to the Fair Work Agency now, because it's a point that's been sort of raised a couple of times, and I just wanted to sort of say an anecdotal story. So, HMRC actually do employ investigators, and that sounds really strange to say as an HR professional, but for years I just thought they're a myth. I've never met one. That can't be true until a few years ago. I was up in Yorkshire for Christmas, and the Uber driver happened to be an HMRC investigator, and he also was an Uber driver for the moments when he wasn't as busy. And I just went, okay, that's interesting, because you know they do exist, and this ramping up of fairness across work is a government priority at the moment. So do we need to be worried about the introduction of the Fair Work Agency? I've heard that they will be able to bring claims to tribunal on behalf of employees, even if the employee themselves hasn't instructed this. Is this right?
It is right. They are going to be able to bring claims on behalf of employees if they think there's a case for it. So it doesn't necessarily need an employee to go to them and say, this has happened, not getting anywhere with it, can you help? If they identify something and they think there's a strong case, then yes, absolutely, they can claim to tribunal on behalf. I think it's not something to be worried about as such. It does change the enforcement landscape, but because they're going to be able to step in and enforce certain employment rights without relying on the individual employees. But all it means is you need to get the basics right, essentially. So when we're looking at core T's and C's around sick pay, holiday pay, any of the statutory entitlements, all the stuff that come under the standard stuff in contracts, you just need to get it right. If you're compliant and if you're transparent about it, you're not going to have any worries about the Fair Work Agency. If you're relying more on people not raising problems to you and thinking there might be something going on, that's where the risk is going to sit. So it's just making sure that contractually, you are compliant, those things are fair, you're being transparent about everything, then there's not going to be any need for the Fair Work Agency to step in. And also just to highlight, it is only around these core T's and C's, they're not there if there's an ongoing dispute around performance, for example, or a disciplinary stance, something like that. It's quite tightly ring fenced around those elements.
Yeah, and it's interesting because I think what it's saying is there's this, with these legislation changes, it's a generational shift towards better working practice across the board. So in many ways, I think there's probably many people on this call and more widely that will celebrate that this is a positive step forward in many ways. Just more work to be proactive, but that once we've got used to that, that's again becomes part of our norms, doesn't it? So I want to make sure my business is family friendly, and I've heard that there are some rights changing around pregnancy and maternity, as well as the right to unpaid parental leave. Are there any other rights changing I should know about, and what, if anything, can I do to ensure my policies and culture are family friendly?
So paternity and unpaid parental leave we covered before in the timeline. So they are changing in terms of day one rights from April. Regarding pregnancy and maternity rights, currently what's in place is automatic unfair dismissal protection if you're dismissed because of being pregnant, or on maternity in redundancy situations, as well as the whole being able to be offered a suitable alternative role as well. Currently, outside of that, employers are still able to go down the dismissal routes in terms of conduct, capability, and so on, if they can show that it's unrelated and fair, but obviously still very risky. But from 2027, that the bar on that whole thing is going to be raised a lot higher, because the intention there is to protect employees beyond the point that they return from mat leave. So not only related to redundancy situations. This is here really to encourage employees to recognise that upon returning from maternity leave, things can be very different for an employee. And it's that grace period of they need to settle back in. Capability and performance might fluctuate somewhat. That's just is to be expected in a way. Like, nobody's going to come back after maternity leave and just be straight back doing exactly what they were doing before. Like, that expectation is just, quite frankly, ridiculous. But it will cover these type of elements. So it will give that period the employee time to be able to adjust. So it's going to be important for employers to really support during that period and make sure that plans are in place, adjustments are made as normal, that they understand that caring responsibilities are new for the person, or they might, they're disruptive. So there's that element. I think probably the other thing to do that is obviously avoiding any snap decisions that might come out because you think somebody isn't performing a few months down the line after returning. Like, you just need to think really carefully about it, because it's going to be very high risk. Now, you're not going to be able to just dismiss somebody for those reasons.
Yeah, and that's a biggie, isn't it? Because those are the things where, that is 78,000 women a year get made lose their job, I should say, as a direct result of having a baby. So we do see that there's quite big numbers of women that are discriminated against for this. So actually it is about just being perhaps a lot more fair and equal, but also being a lot more aware of what the legislation actually says. And I think that's one of the things that we see is a bit of a blindness to what legislation is and what fairness looks like. Okay, I'm going to move on because I'm conscious of time and we've still got a few questions to get through. So I've heard that bereavement leave rules are now changing under the Act. We already have a number of paid bereavement leave days for employees. Do we need to do anything else here?
Probably not, no. I would say that I think this is one of those things that a lot of people think is already in place around statutory bereavement leave, because most employers provide it just out of compassion. But it isn't actually a statutory requirement to provide bereavement leave for employees. The only exception to that is parental bereavement leave. So there's a statutory element in there around providing parental bereavement leave. But this basically stretches that scope in 2027 to make sure that statutory bereavement leave is provided to all employees. Although it's something that will be unpaid, I believe, at this point.
And from day one, right?
Sorry.
And from day one in once
2027. Yeah. So I'd say, where most places provide bereavement leave, it's normally paid. There's normally, around 5 days that are paid. So if you've already got that in place, you're ahead of this change in law. Just, check your policies around it, but I wouldn't think that anything needs to be changed there.
Yeah, and it's a reasonable compassion thing at the time as well, isn't it? Sometimes, you can be more discretionary, but always get advice on that, I'd say. With employees now entitled to a statutory sick pay then from day one rather than day 4, is this a good thing? I'm worried people will be taking time off if all the time, if they can get sick pay all so easily.
Yeah, it's a fair concern. I would say, from a lot of the evidence that we tend to see, it doesn't really show like a mass abuse of the system in that way. So yeah, in terms of what's changing in April 2026, obviously we've already said there's not going to be a 3-day waiting period anymore, and there's also going to be no lower earning limit. So SSP will be a flat rate, or 80% of the earnings, whichever is lower. So what I would say here is you're going to need clear absence policies for a start, so that you know what processes you're following and making sure that there's consistency there. Return to work conversations are also important, and how they're managed and what's discussed. Distinguishing genuine illness from any patterns that might be occurring as well, where you can actually identify trends of what's happening and going on for someone. One of the benefits of this happening is it should really reduce presenteeism, because a lot of people who only get SSP when sick will still come into work when they're too ill to be at work, because they can't afford not to be. And actually in practice that often leads to longer absences, because they're not giving themselves the time to rest and recover. It leads to mistakes, to further issues. And also, obviously, if you are office-based or somewhere with a team, there's more likelihood of that illness spreading to others as well. So supporting people to take, short, genuine time off can reduce the disruption overall rather than increase it.
Yeah. Okay. Well, that's brilliant. Thank you. I'm really comprehensive. So next question. I feel overwhelmed by all the changes. And what policies should I be changing now and prioritising? Should we ensure all our team are aware of the changes too?
So definitely not alone in being overwhelmed with all of the changes, but I think to start with, you should focus on creating an internal roadmap of the changes that are happening. So take the timeline of the events that are happening over this year and next, but really detail how those impact your organisation in particular, and what you need to look at, who that impacts, and then who's going to be responsible for making changes. Making sure that that's timely, and you work in communication times with employees so that they're done at the appropriate times for each phase, and you're giving enough space for questions to come back before it's all enforced. And that obviously does mean making sure your policies and any contractual documentation are all done and ready before this change happens. So once you've got that roadmap in place, I would then obviously focus on the April changes as your first point of call. So for now, that will be your sickness policies, any family leave policies that you've got in place, your performance and probation frameworks, redundancy processes if staff numbers could trigger potential collective redundancy, reviewing contracts around information like sick pay. But I'd also probably take the opportunity whilst reviewing contracts to ensure you're happy with the core T's and C's in there based on what we've already discussed, and the later on introduction of the fire and rehire situation. Because otherwise you're going to then come to October again and go, oh, we need to review the contracts again. Like, you need to just do it all in one go and know what you're looking at. Something that's key around this as well is manager training.
Yeah.
Like with all of this, managers need to be up to speed. They need to understand. They need to know how to have conversations. They need to know what the increased risks are. So there's a lot of different training in different areas that is likely to be needed depending on where you are in the organisation with training. To answer the bit about does everybody need to be informed right now, aside from the manager training side, so they will need to know. For the April chunk, I'd say look to roll out comms, Feb to beginning of March time, and ensure that your policies and everything are finalised before then. And then I'd give the same type of timeline for October, but obviously, prepare in advance for all of that as well.
Yeah, exactly that. Okay, brilliant. Okay, last few questions and then we can open it now. So I've seen there's no longer a ban on 0-hour contracts being used, but these are being tightened up. So 0-hour contracts are really essential for how I employ people. What should I be doing differently now? It's a really good question, this.
Yeah, the good thing is there's no ban on there, because I think that would have made everyone's lives very, very difficult. But yeah, you're right in that they are being tightened up. So this is happening in 2027, where the big one around here is the right to guaranteed hours if patterns do show regular work, as well as compensation for cancelled shifts. So there's a lot more like admin and costs that comes with 0-hour contracts now, unfortunately. What you need to be doing now is auditing in your company who is on 0 hours, map them out. So also not only 0 hours, but low hour contracts as well. So map them out and the working patterns, what they look like in reality, because sometimes whatever's in the contracts is not the actual real life situation. If you identify that hours are stable, then you should expect basically an obligation to be able to offer them guaranteed hours later on. Have a look and decide whether hours do genuinely still make sense for you and can be justified through the business. If you're working with shifts, audit, shift cancellation patterns as well. It's a good opportunity to identify when you're looking at this where flexibility might mask any poor planning in terms of workforce planning as well. And that can then feed into workforce forecasting, rotas, if you work with rotas as well, that type of thing. So then you'll need to consider whatever that internal process looks like for you as an organisation for offering guaranteed hours, but also what happens when they're refused, because it's, just because you offer it and you have to offer it under this new law doesn't mean that person wants it. So it's tying up the whole process cycle from that point of view. Also contractually, obviously you're going to have to look at wording in there, because a lot of 0-hour contracts obviously implies no obligation. So it's removing all that type of language throughout it and making sure that it's really fit for purpose. I would definitely get professional support to look at a 0 hours contract.
Yeah. And again, more work, isn't it? It's not more work in this.
There's a lot more admin for 0 hours for sure.
Yeah. And again, it just speaks to the word proactive here, doesn't it? It's just, I think this whole legislation is pushing employers to be a bit more proactive, less passive around employing people. If you're investing your business money in employing people, then you kind of need to be much more on it in terms of how you manage them. Okay, so we're moving on to the last couple of questions. So a protective award for breaches of collective consultation for redundancies has now doubled. You did talk about this a little bit earlier. Increasing penalties for employees who fail to consult properly. How does this affect our business, and do the limits change for the numbers of people who would need to be consulted on collectively?
So obligations to consult collectively applies when the business proposes to make 20 or more employees redundant within a 90-day period. That's currently at one establishment, but that is also something that's in the Act that is going to change come 2027. In terms of this part, with the doubling of the protective award, just like everything else, it shouldn't really concern you if you're following a fair process. But as we know, with redundancies and consultation, it doesn't always go that way. So it's going to be really imperative to make sure that you're planning out properly any consultation that's required on a collective stance, because it takes a lot longer than individual consultations that happen for under 20 employees. If you do get it wrong, then yes, the risk is going to be drastic, to be honest.
Yeah.
It's going to become very costly. So at the moment, the protective award is 90 days grace pay for the employee. So that being doubled to 180 days, and that's based on that specific employee's salary. And if you've got a number of people who are disgruntled and they're all, going to tribunal over this, you've got a hell of a cost coming out of there. Because also, don't forget that this award doesn't cover compensation for loss of earnings or anything like that. This is purely a protective award for failure to follow process. So the tribunal can award the protective award for either failure to collectively consult in time, failure to consult properly or meaningfully. And the meaningfully one is really important because a lot of people fall down on that, or at all. And people will be, in some situations, will be able to claim like a basic award on top of that and a compensation award on top of that. So, and there could even then be things like discrimination. So your costs could actually be completely endless, and it could leave you bankrupt. So you really need to get this one right. There's no cap. I think something about limit in the question about do the limits change? No, like that's just what it is. So per employee who's affected will be able to claim the 180 days pay.
So I mean, it's there have been some sort of headline companies over the last couple of years, and that I can think of that where this relates, and it does happen. It is a reality that people don't consult properly and so on and so forth. That's not doing this is just churlish. And I think also all of this speaks to this sort of fair work agency kind of mindset of pushing people to actually think a little bit more in the favor of HR. Really, it works for us in so much as you've got to start following process and fairly, and actually there's no longer a time when you can just wing it on the back of a fag packet, sadly, because that really just isn't a thing. So final question. I've read about businesses now needing to inform employees of their right to join a union. So we talked about the unions earlier. How should we do this in practice? Is it something that should be included as part of our onboarding process?
Yes. So under this change, employers are going to need to provide a written statement confirming employees' right to join a trade union. Again, this is going to apply to across the board to everybody. We think at the moment that the government's going to provide a template potentially for this to make sure that wording's aligned and there's not much deviation from that. So that will massively help people. If they don't do that, then seek some HR advice around what's appropriate. But we're waiting to hear on that bit. So definitely include it in things like your offer packs, onboarding process and so on. But there is also the obligation to inform existing employees. So you need to do your statement to existing employees, and then also annually inform employees. So it's working that into your internal processes to make sure that you're not missing doing this when the time comes.
Yeah. Okay, that's great. Okay, thank you so much. That's great. That's all the questions. So I'm just going to sort of finish this before I open it out to any more questions. Just wanted to mention that obviously we're here to support you and help you. So you can sign up to our newsletter. You can sign up. You can send us an email at info@freshseed.co.uk. Our next clinic will be on managing relationships and preventing sexual harassment in the games and creative sectors. That will be on the 11th of February at 1 o'clock. Details are in our newsletter, on our socials, and available. I'm thinking probably our marketing person's here today, so she will possibly shout at me if I've got something wrong there. And I think Paul can put some info in our chat about kind of the info app and what have you. If you need to ask any questions, feel free to ask them, and if you want to pick it up separately with us and just pick our brains separately, feel free to do that too. So I'll open it out to anybody for now, and if not, you've got a few minutes left of your slot to go off and have a cup of tea. Thank you for joining, everyone. It's been so lovely to have people with us for this one, and I hope to have you on future clinics.